Thank you very much, Amira, and thank you very much to the organizers for, I know the gestation period's been a while coming, but for pulling this together. It's obviously, it's a great honor to be here today, even though you've given us the graveyard shift at the end of the day. Certainly a great honor to be sharing the platform with Obi. And it's been just a rich opportunity to soak in all of the wisdom and experience and insights in the room all day long. I am honored to have traveled from unceded, unsurrendered Algonquin Anishinaabe territory here to the territory of the Confederacy of the Three Fires. And am very aware and very much acknowledge that we're coming together today on this very important day, the National Day of Truth and Reconciliation. And I guess I want to maybe begin therefore by sharing a bit of a pledge, my pledge with all of you as to what that means for me today, but I think all of you would agree, even though we focus on it today, this is really about every day. And that is that I pledge to always both seek and live truth, to embrace and advance reconciliation, and to always, in that journey, be guided by the rights of Indigenous peoples. And that's a bridge, I guess, to my remarks, which are going to be all about rights. And I'll begin with the good news. That's about the first two sentences of my remarks. No, don't worry, I will have positive observations from time to time, but let me begin with the good words, and that is, we live in a world with an abundance of stirring human rights commitments. It would in fact be impossible to even begin to catalog all of the words that have been put to paper over the decades, enumerating a wide range of rights, touching really virtually on all aspects of human existence. Yet, you know that was going to be the next word, or but, despite all of that promise, we live in a world overflowing with widespread human rights abuse. Devastating armed conflict ravages today, Ukraine, Syria, Yemen, Ethiopia, and many other countries. Disregard for the rights of Palestinians deepens. Genocide continues to unfold against the Rohingya and Uyghur people. Today, we remember that Canada is far from reckoning and reconciling with our own history of genocide against Indigenous peoples. And then more widely, hate and misinformation lay the ground for toxic human rights abuse, I think we can safely say, in every corner of the world. And certainly governments of all description commit grave human rights violations in the name of national security, again, in every corner of the world. And that was the case long before the US unleashed its infamous war on terror. But in our world today, genuinely, perhaps, certainly cynically and opportunistically, governments both assume or shamelessly pretend that insecurity somehow allows them to put human rights to the side. The place of human rights, therefore, in our world seems to actually come down to one's choice of conjunctions: security and human rights, security or human rights, security versus human rights, security through human rights. Who'd have ever thought that grammar has such consequence? Well, I'm going to focus on two fundamental currents that undermine the protection of human rights when national security is in the frame. First, and perhaps a bit more quickly, the false debate about what's often termed a trade-off between rights and security. And then second, the related abject failure of accountability when rights are violated in the name of security. to frame this, I'm often very kind of cautious and tentative about even getting into this discussion about the debate, because to frame this as a debate is itself a fallacy, because it's somehow premised on viewing the relationship between security and human rights as if it's a zero-sum game, right? If we want greater levels of security, then human rights have to come down. If human rights is what we're really concerned about, then we have to be prepared to accept a greater amount of insecurity, which is, of course, absolutely absurd. There is nothing about our world that makes it insecure because we are somehow awash in human rights. We're not insecure because we deliver too much rights and justice. Quite the opposite, obviously. We are insecure because of failing to commit to everything that human rights entail. Let me step into the world of international human rights for a minute. I won't be overly legalistic throughout all of the comments, but hey, this is a law school, at least partially sponsored conference. I want to step back in time briefly to 1945, when the Charter of the United Nations was finalized. It was a tough time. The world was emerging from the horror of World War II, was reeling with a growing understanding of the deep evil of the Holocaust, and was really struggling to figure out how to heal hatred and divisions in the world. And the answer, assembled leaders knew, lay in global community. And at that telling moment in history, in the very first line, so not buried in Article 72 or something, but in the very first lines of this bold new charter, what do we have? Human rights. We, the people of the United Nations, determined to reaffirm faith in fundamental human rights. And they stuck with it. In 1948, leaders came back together and proclaimed the Universal Declaration of Human Rights, which also opens with a powerful affirmation, this time that recognition of the inherent dignity and the equal and inalienable, I always have a hard time with that word, inalienable rights of all members of the human family. And listen to these last words, because I think this is what kind of connects us up with this, right? Security debate piece is the foundation of freedom, justice, and peace in the world. Of course, it didn't end there. And in the years and the decades that followed, governments have crafted an international human rights order that takes full account of the security imperative that they were the ones writing these words, face. Some rights, such as the freedom of expression, incorporate national security into the very definition and scope of how the right is written in the first place. Others, such as fair trial rights, are written in absolute terms, but can be subject to extraordinary derogation when a sufficiently pressing national emergency arises. And then a third category of rights, which includes the protection against torture, are absolute and non-derogable, which essentially means nothing ever, for any reason, can ever justify their infringement. Now that's a 1-minute description of what, of course, is an entire international human rights law course. But I think the point to take away from that is that when it comes to security, we do not need to look beyond human rights. It's all there. It's all anticipated. It's all included. Yet, there is always an excuse, a backdrop against which governments argue that their failure to embrace human rights is justified. And that is certainly so when it comes to national security. Security first, human rights for another day. But if so, that means we are agreeing to a world divided, unequal, and full of violence. And don't rely on me for that view. Senior judges from around the world have repeatedly made that point in numerous rulings. I don't always quote the Israeli High Court, but let's start there. Israeli High Court President Aharon Barak, in a 1994 ruling dealing with interrogation techniques. This is the fate of democracy, as not all means are acceptable to it and not all methods employed by its enemies are open to it. Sometimes a democracy must fight with one hand tied behind its back. Nonetheless, it has the upper hand. Preserving the rule of law and recognition of individual liberties constitute an important component of its understanding of security. At the end of the day, they strengthen its spirit and strength and allow it to overcome its difficulties. The Supreme Court of Canada's 2002 CRS case, on the other hand, stands the need to ensure that those legal tools do not undermine values that are fundamental to our democratic society: liberty, the rule of law, and the principles of fundamental justice, values that lie at the heart of the Canadian constitutional order and the international instruments that Canada has signed. In the end, it would be a Pyrrhic victory if terrorism was defeated at the cost of sacrificing our commitment to those values. And on it goes. The false debate about security and human rights has been particularly troubling when it comes to the prohibition of torture. And I think it's really important, before I move on to the accountability piece, just to remind ourselves, and I know I'm not amongst people who need this reminder, that we simply cannot ever justify torture. And there's all sorts of pragmatic, torture doesn't work, torture, it's a fallacious notion that you get good information. I don't even want to go there. I just want to remind us that torture needs to be rejected because of what it is. And that in fact, it is so destructive to the notions of integrity and dignity that are the very essence of fundamental human rights, that it shatters security every single time there is a single act of torture. But let me move on to the second issue, because I already got my 10-minute warning that I want to explore. And it's a companion to the first. And it's not enough to hope that we're somehow going to be able to shift that debate. By me simply saying it's not a debate, the debate's over. Rights and security, there's no trade-off. We need to think about what it is that's going to shift that debate. And accountability, justice, impunity is so crucial here. Because impunity prevails, absolutely, when we're faced with national security-related human rights violations. And we've got to not just pierce that, but shatter it. Impunity, of course, more widely has long been an insidious obstacle to human rights in any context. We've got clear international legal standards about remedies and justice and redress. Yet we live in a world where still human rights violations are shrouded in secrecy, and where at best accountability is a very occasional and elusive dream. It's been shifting a bit. We have the International Criminal Court. We've had international tribunals dealing with the former Yugoslavia and Rwanda. We have some national courts that are starting to take action. We've had a number of truth commissions convened around the world. And of course, today, very much on our minds is Canada's example, the Truth and Reconciliation Commission. Yet the gains in piercing impunity remain tentative. Let's not forget that the need for justice and accountability isn't just some sort of goal or objective. It is in itself a right. And all of those international human rights documents that I briefly referred to make that very clear, that alongside the catalog of freedom of expression and equality and the right to education are clear elaborations of the right to a remedy, the right to compensation, the right to redress. So even when we're thinking justice and accountability isn't just a solution, it's a right. And it's a right that prevails no matter what. The UN Human Rights Committee has made it very clear that there's still a right to a remedy during times of national emergencies. Numerous UN special experts have talked about the importance of remedies in connection with national security itself. So where do we stand? How does this play out in Canada? I think casual observers at first blush might think, if they've been following this at all, would think, we're actually doing kind of good. There's been some high profile cases that have been resolved and settled. In 2007, Meher Arar received compensation and an apology for Canada's role in his ordeal of arbitrary arrest, detention, and torture in Syria. Following his release and return to Canada, a judicial inquiry had looked into his case and had cataloged the ways in which Canada did him wrong. In 2015, a little bit less known, Benamar Banata settled his lawsuit seeking compensation for harms he experienced after Canadian officials, this was on, listen to the date carefully, September the 12th, 2001. And on that day, he showed up at the Niagara Falls border crossing to make a refugee claim. And rather than receive his refugee claim and deal with it, as is the law, Canadian officials booted him back across into the hands of US officials. And he disappeared into horrific detention in the United States for 5 years and was beaten and abused throughout that time. He's been compensated. In March of 2017, Abdullah Al-Malki, Ahmed Abu Al-Mati, and Muyad Nuruddin received compensation and an apology for the role of Canadian officials in their arrest, detention, and torture in Syria, and in Mr. Al-Mati's case, also Egypt. And of course, in July of 2017, Omar Khadr received compensation and an apology for Canada's role in the long litany, the decade-long litany of abuses that began at Bagram Air Base in Afghanistan and then continued forever at Guantanamo Bay. Maybe that sounds impressive to you, maybe not. It is not, however, an indication that we've got this right. And let me just share with you some of the shortcomings. Number one, despite those 4 cases, there are active cases right now where exactly the opposite is happening. Abu Sufyan Abdul Razik was subjected to arbitrary arrest, unlawful imprisonment, and torture. You hear a similar litany of human rights abuses in all of these cases, this time in Sudan. And CSIS officials were centrally involved in both initiating and prolonging his detention. At one point, it looked like Canada was about ready to settle his case, but overnight, and this was during the Trudeau government, that changed, and he's now stuck in protracted, prolonged litigation. The UN Committee Against Torture has chastised Canada for this case. Hassan Diab was extradited from Canada to France in 2014 on charges that he was responsible for a 1980 terrorist bombing in Paris. The extradition judge at the time observed that the case against him was exceptionally weak, but held that his hands were tied. He was held in solitary confinement in a French prison for 3 years before the charges were dismissed. He's returned to Canada, but on appeal, the charges have been reinstated in France, even though the evidence against him has been further discredited. Canada refuses to intervene with the French authorities to say enough. Back off, let's bring this to an end. Also missing in all of this is the accountability of specific individual officials responsible for what happened. So the Canadian government keeps writing checks and keeps issuing apologies. We were hearing this morning about how we kind of seem to have moved into a new era of, once upon a time, apologies were never forthcoming. Now it sometimes feels like they're a weekly occurrence, but do they mean anything? But where's the individual accountability for the individuals who were responsible for this? And that we don't see at all. Certainly no criminal investigations, let alone charges, not even what we might minimally expect in some disciplinary consequences in the workforce. Quite the contrary, some key players, Giuliano Zaccardelli, some of you will remember him, commissioner of the RCMP at the time of Arar, Al-Mati, Nuruddin, early days of Omar Khadr. He was forced to resign in 2006, not because of what the RCMP was responsible for any of those cases. He was caught lying to Parliament, is why he had to resign, and then moved on to a very cushy senior role with Interpol at the international level. Mike Cabana, also an RCMP inspector at the time, centrally involved in all of those RCMP investigations. No criminal investigation, no disciplinary action, quite the contrary. He was later promoted first to become an assistant commissioner and then a deputy commissioner, number 2 within the RCMP. So not surprisingly, the problems continue to arise. And I point to none other than a very serious concern about how the government is handling at least 44 Canadians, half of whom are children, who are held and detained in inhumane conditions. I'm going to beg 1 extra minute from you. Inhumane conditions at the hands of Kurdish forces in northeast Syria. And Canada refuses to lift a finger. Canada refuses to simply abide by their obligations to protect their right to free them from what's happening there and allow them to repatriate to their country of nationality, Canada. Again, the UN, actually UN Special Procedures mandate holders, colleagues of our dear friend Obi, 5 of them have come together and have taken Canada on and have demanded that repatriation be facilitated. So let me end. The activist in me always wants to kind of end with, what do we do? What's the agenda? And I'm going to give you 8 really quick, and don't worry, it isn't going to go on forever. It's like a sentence for each one. But here's 8 steps that I think we should expect at a minimum from the Canadian government to start to shore up regard for human rights and ensure justice and accountability in national security cases. First, provide full and adequate redress to Abu Sufyan Abdulrazik and Hassan Diab for the role of Canadian officials in the human rights violations they've experienced in Sudan and France. Second, act on those recommendations made by UN Human Rights Council special procedures holders regarding the repatriation of the Canadian citizens arbitrarily detained in northeast Syria. 3, amend all national security laws to include an explicit requirement to comply with Canada's international human rights obligations. We shouldn't need that in law, but we do. 4, reform the State Immunity Act. I didn't have a chance to get into this, but reform the State Immunity Act to allow civil lawsuits in Canada against foreign officials accused of responsibility for human rights violations that are crimes under international law. 5, request the National Security and Intelligence Review Agency to carry out a review of the failure I've just described to pursue criminal charges or disciplinary measures in any of those cases where compensation has been paid by the Canadian government to individuals who experienced human rights violations in the context of national security operations. 6, let's look at some institutional reform. Initiate public consultations to consider options for establishing an independent commissioner or some other body to oversee accountability in cases involving national security related human rights violations. And then 7 and 8 more broadly. 7, develop legislation to finally effectively implement international human rights obligations in Canada, because we do a lousy job, not just when it comes to national security, of actually implementing our obligations domestically. And then lastly, institute an international human rights action plan for Canadian foreign policy. Imagine if we actually had an approach that consistently put human rights first. Thank you.